Uh, Greetings to everybody, and welcome to drafting and its basic principles by lawyer D. Yashwanth Kumar. Sir is a member of the Andhra Pradesh Bar, and he's a practicing. And sir will be taking an expert session on drafting and its basic principles as it's an essential skill for every lawyer or uh, uh, any person related with the field of law. I humbly request Sir to take over the session. Before we start, I'll just explain the format of our session. Sir will have 30 to 45 minutes to address the session, and in this time, I request people to refrain from unmuting yourself and asking questions as and disturbing Sir. Instead, you can put a question in the message box, and as per Sir's discretion, those questions may be taken up. In the end, after our 30 or 45 minutes of Sir addressing the session, we'll have a 10-minute Q&A session where you can raise your hands, and on a first come first serve basis, I'll ask you guys to unmute yourself, and you can ask Sir your questions. Sir, please take over the session, sir. Thank you.
Yeah. Thank you. Good evening, everyone. As the host mentioned, I am Yashwanth Kumar, practicing advocate at Rajahmundry Bar Association and at Rajahmundry District Courts as well as at AP High Court. So, and I'm a recent law graduate. I have graduated with law degree from in 2023. So, yes, today we are going to discuss about drafting and its basic principles. So, basically, I have divided this class into two parts. On first part, we are going to discuss about what is drafting and basic principles of drafting. And second part, we are going to have a live drafting of a plaint of a civil suit, which is based on a factual pronote scenario. So, without any delay, let us start our session. And as the host told you earlier, I also kindly request you not to disturb while the class is going on. And yeah, let us start the session. I am sharing my screen now. So, yeah, is my screen visible? Can anybody confirm it?
So the screen is still loading. Yeah, now it's visible, sir.
Yeah. So, drafting and its basic principles. Yeah, let us start the session. So, yeah, anyone know? So, yes, since I told everyone to not to disturb the session, I will continue in a flow. Just let me know if I'm going fast. And yes, what is drafting? So, drafting is nothing but the art of creating written documents, particularly legal documents, since we are legal professionals. So, particularly creating legal documents, contracts, and agreements. So, in drafting, we will have very complex ideas, and we have to make sure that we have to transform the ideas into clear conscience and accurate language because client will come to us and tell about his dispute and the problem he is facing. But what happens is that we cannot include all of the details which the client is saying because there might be some details which are not essential for the suit because since they are laymen and they don't know about law and the legal procedure and all, they will tell us everything and we should have to listen to everything, and we as a legal professional we have to analyze the data the client gives us, and we have to ensure that we incorporate the information, and we have to incorporate which is very essential for the case. And moving on to the next, importance of drafting. The importance of drafting is that we should have to ensure clarity and avoid misunderstandings in legal matters and agreements. Because if there is no clarity, then it will lead to certain uncertainty in the case. It may go to an extent which no one can bring the case back to its initial position. Or, if, for example, let us take that we have filed a case for recovery of money, but in that we have missed to add certain amounts, like for example, interest. We have deliberately or mistakenly forgot to mention 1 lakh rupees of interest. What happens is that we cannot again file a case on the defendant and we cannot ask for it. So always ensure clarity and avoid misunderstandings while drafting. And drafting protects the rights and interest of all parties involved. For this, we can take like partition suit, because in a partition suit, plaintiff will file a suit against the defendants, saying that divide the property into equal shares and give one such share to me and allocate other such share to the defendants. So, drafting does not take away the rights or interest of the parties involved. In fact, it protects the rights of the parties. And moving on to next, basic principles of drafting. These are the basic principles of drafting which I have created, but these are not. I have created only these basic principles as three. First is clarity, or second is organization and structure. Third is accuracy and completeness. So let us discuss what are these three one by one. First, clarity. Clarity. Always use plain language and avoid jargon if possible. That means jargon is nothing but a language which is used by certain professionals and cannot be understood by others. As legal professionals, we may come across about some Latin maxims and all. But if we ask a common citizen about the legal maxim, no one can say what it is. They don't even understand the legal maxim. So that is why always ensure that you are using plain language in drafting so that there will be certain clarity, and keep the sentences short and to the point. For this example, we may see like certain reels in Instagram, so that if we don't know any, like there will be keeping like movie shorts or reels in Instagram and YouTube. For example, if we don't know what is the scenario or context of the reel, we will ask like, can anyone explain where is the paragraph guy, like that. But if we write the paragraphs and so in our drafting, it will make it very. There will be so much verbiage and difficult. There will be so much of difficulty to read it all. So always keep your sentences short and to the point. And next is avoid ambiguity and double meaning words. If there is ambiguity in the case, no one can do anything. So always make sure to avoid ambiguity and double meaning words, and always stick to the point, and make sure you're making everything clear to the crisp, making the facts clear and all. So let us see an example for clarity. So example. See this example. It is the defendant's action constituted a tortious interference with the plaintiff's prospective economic advantage, thereby causing substantial damages. So while reading it, we can say that it is very confusing, because there is it is not easy for for a common man to understand what it is. And let us see how we can make it simpler. The defendant's action unfairly prevented the plaintiff from making a potential business deal, resulting in significant financial losses. So can you point out any difference between these two? The first sentence uses legal jargon and complex phrasing, making it hard to grasp the point. And the second sentence is very simple and simplifies the legal concept using daily life language. And
Excuse me, sir.
yes,
So the slides are not changing. It's the first slide on the screen.
first slide. Let me see. Just a minute. Hello. Is my screen visible to everyone?
Yes, sir, it is visible now.
Yes. So yes. Yes. Look at this the example for clarity. The defendant's action constituted a tortious interference with the plaintiff's prospective economic advantage, thereby causing substantial damages. And we'll move on to the simpler one. Just a minute. Yes, the defendant's action unfairly prevented the plaintiff from making a potential business deal, resulting in significant losses. As I have discussed earlier, there is legal jargon in the first sentence, and the phrasing is very complex and making it very hard to grasp the main point. While coming to the second sentence, we can see that the legal concept is very simplified and using very everyday language, so that someone reads it, it can be easily understood by uh, the one who is reading it. So let's move on to the next. Organization and structure. Is the slides moving, or is it stuck to the first one? Can anyone confirm it?
So we are on the slide of example confusing.
Yes. So it is not moving, I think so. Right now?
Yes, the organization and structure.
Okay. Yes, I'm thinking that full screen is not working. Let us continue like this. Organization and structure. So, while drafting, always follow a logical order for presenting information. I mean that while drafting, we may come across certain dates, like something happened in 2019 and the other in 20, another in 22 and 23. Let us consider that we have to follow the logical order from 19 to 23, but we should not go from 23 to 19. So always follow this order. And next, use headings and subheadings for easy navigation. When, as a law students and legal professionals, we read many acts, and when we see the index of an act, let us consider IPC. There are certain chapters in IPC, and first chapter is named as introduction, and second as general explanation. And in that every chapter after the heading, there are certain sections, section 1 to 5, like that. So always use headings and subheadings for easy navigation, because if there are more than 20 paragraphs or 30 paragraphs in a plaint, it would be hectic to read every paragraph and all without any navigation. So if you use headings and subheadings in those kind of drafts, it would be very easy and it will look very impressive to see such a draft. And always number the paragraph for clarity, because many will give like bullet points and something like that they use, but don't do that in drafting. Always use paragraph numbering for the paragraphs. Yes. Let us see an example for this organization structure. So here is a scenario. Yes. Imagine you're drafting a will for a client with multiple beneficiaries and special bequests. Let us see first the disorganized one. Disorganized. Yes. Here it says that I leave my house to my son Mark. To my daughter Sarah, I bequeath all my jewelry. The family dog Sparky shall go to my nephew David. The rest of my belongings will be divided equally among my children. So see, it is completed in one single paragraph, but it is very disorganized, because there is a house lived by the person to his son, and to his daughter the jewelry, and to his nephew a dog, and all the other belongings should be divided equally among the children. So let us see how an organized draft will look like. The same sentence. Yeah, organized one. First, there is certain numberings, as you can see, 1 to 3, and then there are headings, tangible personal property, and then in that there is a subheading like residence, to my son Mark, and jewelry to my daughter Sarah, pets to my nephew David. And second, we're coming to the heading, it is residuary estate. All remaining personal property shall be divided equally among my children. And third one, additional provisions, funeral arrangements and charitable donations are to be looked after by my son, daughter, and nephew. So the first example is like very confusing, and there is so much of ambiguity in it, because there are yes, it is completed in single paragraph, leaving for scope of ambiguity. But when comes to the second one, which is organized one, it is isolating specific bequests and addressing residual belongings separately, which ensures clarity and minimizes risk of disputes among the beneficiaries. So, next, let us move on to the third basic principle, accuracy and completeness. Always ensure that all facts and information are up to date and address all relevant issues and potential problems in the draft. And let us see an example for this accuracy and completeness. Imagine you're drafting a power of attorney for someone to manage your financial affairs while you're abroad. let us see first what an incomplete draft will look like. Yes, I grant Mr. A power of attorney to manage my bank accounts. So see here the draft is very incomplete and there is no accuracy in the draft. Uh, so let us see what an accurate and complete draft will look like. Yes, I grant Mr. A residing at Delhi full power of attorney to act on my behalf for the following purposes: access and manage my bank accounts at, if there are multiple banks, all the names of the bank should be disclosed, including depositing and withdrawing funds. Second, pay bills and other necessary expenses on my behalf, sell and purchase stocks and other investments with these accounts. Following these investment guidelines, if there are any relevant documents, they should attach the documents, or any instruction, they should specify the instructions. And fourth, this power of attorney shall be effective from so and so date and shall expire on date unless revoked earlier in writing. So here the first version only specifies the action without any details. Here I grant Mr. A power of attorney to manage my account. There is only action that power of attorney was granted to Mr. A for managing bank accounts. But the second version, where we see the complete version or accurate version. Hello. Yeah. The second version, when we see that the scope of the power of attorney's authority, including specific tasks, are clearly specified, and there are the limitations are also clearly specified, and the duration of the power of attorney and the termination also clearly specified in this. So this is the complete draft and this is the incomplete draft. So always be careful while drafting. Make sure that the details given to you are accurate and complete. Do not make incomplete drafts because it would be very difficult uh, while dealing in court proceedings. So these are the three basic principles of drafting which I have thought the main things. First is clarity, organization and structure is the second. Third is accuracy and completeness. So moving on to the next, language and style. In drafting, language and style is also very important aspect. And there are three important things in language and style. First is formal and formal versus informal. Second is active and passive voice. Third is word choice. Let us see one by one what are those. First, formal versus informal. Always use formal language in legal documents, contracts, and agreements. All use the informal language in less formal documents such as emails or letters. For more understanding, we can say that use the chatting language which is used in WhatsApp and Instagram in the less form in WhatsApp and Instagram, and never use that type of language in legal documents and contracts and agreements. Always use formal language. So let us see an example for it. Imagine you're drafting a clause in a lease agreement outlining the tenant's responsibility for maintaining the property. Let us see the informal approach. You're responsible for keeping the place clean and in good shape throughout your stay. This means things like no messes on the floors or walls, making sure the plumbing, electricity, and heat work okay, and letting me know right away if anything breaks or starts leaking. See, this is an informal approach, and let us see a formal approach. Formal approach. The tenant shall, at all times during the term of this lease, maintain the premises clean and safe. Such maintenance shall include, but not limited to, the following: keeping all floors, walls, and ceilings free of debris and damages, ensuring the proper functioning of all plumbing, electrical, and heating systems, and promptly notifying the landlord of any leaks, malfunctions, or other maintenance issues. So, here in the informal approach, there is no word such as tenant or the owner like that. It is simply said that you are responsible. Here, there is not clearly mentioned who is you are. Simply mentioned you are responsible for so and so and so and so. But in the formal approach, it clearly mentioned that the tenant, the sentence is started with the word the tenant, shall at all times. during the term, and the term also clearly mentioned. Everything is clearly mentioned in the formal approach, and but in the informal approach, it is like a single paragraph. It is like a text is. It is like a friend sending his text to another friend. So this is the example for informal approach and formal approach. And moving on to the next, active versus passive voice. In legal, in drafting, always prefer active voice to the passive voice. Give the least preference for the passive voice because active voice is considered to be direct, and yes, always prefer active voice versus active voice in drafting because active voice is considered to be direct while passive voice is like creating more and more verbiage in draft. So for this an example is like let us see with an example. The cat chased the mouse, and this is in the form of active voice. But the same can be resentenced in passive voice, like the mouse was chased by the cat. And yes, let us see an example in legal backdrop so we can understand it. Yes, active voice. See, the advocate informed the client of the court date, where it is the active voice, but whereas in the passive voice, it is like the client was informed of the court date by the advocate. See, it is creating the meaning is same, but the passive voice is like much more hectic and it is not formal to read it like this. So always prefer active voice over passive voice while drafting, while legal drafting. And moving on to the third one in language and style, it is the word choice. Always use precise and specific language while drafting and avoid vague or ambiguous words, as the ambiguity has already been discussed in the clarity in the first principles of drafting. And let us see an example for the word choice too. Example, the defendant's actions about the property were unfair and wrongful. Here, the word choice is not very strong, and let us see the revised version. The defendant's actions constituted a fraudulent misrepresentation as they knowingly made false statements about the property's condition to induce the plaintiff to enter into the contract. Here, the first sentence doesn't provide enough legal justification, but the second sentence clearly clearly specify the legal term and explain the basis for accusation against the defendant, making the argument more persuasive. Moving on to the next topic is editing and proofreading. In that there are two main heads. Revision and refinement is the first, and second is proofreading for errors. So first, revision and refinement. Always review and revise your draft for clarity, accuracy, and flow. And yes, moving on to the example. I'm completing this first because since there is live drafting of a plane, it will take much time in live drafting. So, yes, example, the defendant is guilty because they did bad things. So, this is the example. And let us see, while you're drafting, a point has been, you founded a point like this, the defendant is guilty because they did bad things. So after revising and refinement, you can't like let it go like this in the final draft of your drafting. So yes, let us see how a revised one will look like. The defendant's actions, as outlined in paragraph numbers 5 to 12 of the plaint, constitute a clear violation of plaintiff's peaceful possession. This violation directly caused severe damages to the plaintiff, as evidenced by exhibits A to C. The first sentence is weak and lacks legal basis, whereas the revised version strengthens the argument by citing specific evidence and reasoning, making it more accurate. Yes. And next, moving on to the proofreading and errors. Always carefully proofread your document for typographical errors, grammatical errors, and punctuation mistakes because even I have an experience of 8 years in drafting, but till today I face many mistakes in my draft. Even I have checked it more and more times, because no matter how many times we check it, there will always the mistakes will always roll out in our draft. So don't just read once after completing your draft. Read 2 or 3 times or more than 5 times. It is best how many times you read it, because there won't be any problem, because you're gaining the subject, and uh, their mistakes will roll out more and more if you read the draft. And yes, let us see an example for this. Mr. A purchased the house for 5 lakhs. See, you have found a point, you have found this sentence in your draft. And yes, there are two mistakes in this one. Mr. A purchased the house for 5 lakhs, but the currency is not mentioned, like rupees. And whereas coming into, yes, this is the corrected one. Mr. A purchased the house for 5 lakhs. Up to here, it is right. Whereas coming to this, rupees is not added, and the amount itself, the commas and all, the symbol is not added in the original one. This is the corrected one. So always make sure to proofread your draft for errors, because I'm sure that I'm saying it with experience that definitely errors will roll out in your final draft, no matter how many times you check it. Yes, and moving on. Yes, conclusion. So, drafting is a skill that takes practice and refinement. By following the basic principles of clarity, organization, accuracy, proper language, you can create effective and impactful legal documents. Well, I must say that drafting is not something that you may earn by reading and all, because drafting, you can master the skill drafting only by practice. Practice is the main key for drafting. It doesn't matter who you are, like you're a first gen advocate, or you're new to law, or you don't know the basics of drafting. It doesn't matter. Practice more and more about drafting, and you have a bail application with you. Draft it thoroughly, to a point where that you can draft the bail application without any support or help. And practice is the main and essential key for drafting. By practicing more and more thoroughly, you will excel in drafting. So, yes, that is the this is the first part of session, drafting and the basic principles. And yes, moving on to the next. So, shall I start the live drafting right now?
Yes, sir, you can start.
Yes. So, yes, live drafting of a plaint. Yes. What is a plaint? A plaint is a pleading of the plaintiff, as we have seen in the CPC and all. But the term plaintiff is not defined in the CPC. However, under Order 7 of CPC, certain rules are framed for plaint. So to make sure that to excel the drafting of a plaint, make sure that you just a minute. I'm sorry. Yes. Make sure that you are well versed with Order 6 and Order 7 of CPC for effective drafting of plaint. And yes, moving on to the essentials of a plaint. These essentials of a plaint and all are created in practical aspect and not in theoretical part. Please take a note of that. Yes. There are 12 essential parts of a plaintiff. First, it is the name of the court and suit number. Yes. Name of the court. While drafting a civil suit, jurisdiction plays a key role in deciding the court, because while let us see that we are since the live drafting is about pronote scenario, yes, territorial jurisdiction and pecuniary jurisdiction plays a key role in the pronote suit. Like when it comes to the territorial jurisdiction, Let us consider that the transaction happened in New Delhi, and both the plaintiff and defendants are residing at Delhi, and the defendant carries the business at Delhi. Then the territorial jurisdiction will absolutely be Delhi. But when coming to the pecuniary jurisdiction, since we know that the territorial jurisdiction, we cannot go and file suit in the district court of New Delhi, right? And we have to make sure that in which court has the pecuniary jurisdiction for the suit. For this, in my state, it is like up to 20 lakhs. The junior civil judge courts, like civil judge of junior division shall have the jurisdiction up to 20 lakhs, and up to 50 lakhs, it is like civil judge of senior division, and more than 50 lakhs, it is for the district court. Will have the jurisdiction in pro note cases and all in civil suits, and that is how you have to make sure to know about the court name. And for the criminal cases, it is easy, like basing on the punishment as mentioned in the CRPC, the court will be specified. And next, the second part is like suit number. Always make sure to give a suit number. No, don't give the number yourself. The court will allot certain number. Make sure you leave a blank space for the suit number. And right after the suit number, you should have to mention the short first title, and then the provision of law for the plaintiff. After that, the name, description, and place of residence of plaintiff in this occupation should also be mentioned, and the same for the and same goes for the defendant. And right after this, we should have to mention the hello. Yes, right after this, we should have to mention the body of the plaintiff. And body of the plaintiff is nothing but brief facts of the case. And after completing the brief facts of the case, we should have to make sure the suit has a cause of action. Cause of action is an essential element which should not be missed in any civil suit, because it is the gist of a case. And right after the cause of action, valuation and court fees should be mentioned, and then the relief or prayer, you can say so, and then the signature and verification. In the signature, both plaintiff and advocates should sign it, and the date should be included. And after that, the verification, the oath and all. And then if there are any list of documents in civil suit, generally there will be list of documents definitely, and you should have to mention all the list of documents by maintaining a chronological date of order. And next, the signature of the advocate. So these 12 are the essentials of a plaint when coming into the practical aspect. And let us see the factual scenario for the live drafting. Yes, factual scenario. Mr. A is a resident of Prakash Nagar, Rajahmundry, and Mr. B is also a resident of Prakash Nagar, Rajahmundry, and Mr. B borrowed an amount of rupees 50,000 on 1/12/2023 from Mr. A to repay some of his loans, and Mr. B executed a pro note in favor of Mr. A at his residence for the said amount, and agreeing to repay the same with an interest of 24% per annum, either to him or to his order. So this is the factual scenario given to us, and it is clearly mentioned that both Mr. A and Mr. B are residents of Prakash Nagar, Rajahmundry, and the pro note also executed at Prakash Nagar, Rajahmundry, and the amount is given, and the date was also there, and so the interest rate. And yes, basing on this, let us draft a plan for the above given factual scenario. Yes. Yes. Firstly, as I have mentioned, there are 12 essentials of a plane. First one is the court name. Always make sure that you start with in the court of the, since the amount is 50,000, the pecuniary jurisdiction falls in junior civil judge court. And so the jurisdiction is Rajahmundry, it will be Rajahmundry jurisdiction. And so that in the court of the junior civil judge, Rajahmundry. And next, in the first one, there is another thing I was mentioned, name of the court and the suit number. For the suit number, since it is a civil suit, you should have to mention OS number of 2024. Don't mention any number here because the court will give the number. Don't give any numbers here. I'm repeating it again. And next, we have to mention the short course title. There is a difference between short course title and long course title, because in short course title only the names shall be mentioned, whereas in the short course title the entire address of the party should be mentioned. So here we have to write first between, and first the plaintiff who is instituting the case here, Mr. A, because he is the one who given money to Mr. B. Mr. A is lender, Mr. B is borrower. So that makes Mr. A as plaintiff. And next, that makes Mr. B as defendant. So next, there are two things right now are completed, two elements, the name of the court and the short course title, and that makes the third one as provision of law. For for a civil suit, the provision of law is that, observe clearly, plaint filed under section 26 read with order 7 rule 1 of CPC, or you can write code of civil procedure, it is up to you, and underline it to make it differentiate from the matter. So the provision for a civil suit is like plaint filed under section 26. Yes, we don't need to read with section 26 order 7 rule 1 of CPC. Next, three essential elements of a plaint are completed. Short course title is completed, provision of law is completed, name of the court and suit number is completed. And now, name and description of and place of residence of plaintiff and defendant. We will write it like name and addresses of the parties. Underline it. First, plaintiff. And let us say like Mr. A, son of Mr. C, and let us like aged about 30 years is just an example, and address is already given, it is like Prakash Nagar, Rajahmundry, and for the district is like West Godavari district, Andhra Pradesh, India. If possible, give a pin code. Yes. Next, defendant. Yes. Let us copy paste this exact same thing because they are having the same address. Here it is Mr. B, son of, let us assume like Mr. D, and let us say the age is same, both are of same age, or else we can write like 28. So here what happened is like long course title is also completed, that is name and description and place of residence of plaintiff and defendants. So up to now, 5 essential elements of a plaint are completed out of 12, and there are 7 remaining. So let us complete the other 12 because we are running out of time. So to differentiate the matter from this address and all, let us give a line so that it won't club in our matter. Yes. Now, let us draft the brief facts of the case, that is the body of the case, body of the plaint. Always remember to make sure to include the name of the advocate in the first point, that is the addresses for this service of summons, notices, process, etc. on the parties are as shown above and on the plaintiff is all is that of his advocate. Let us assume like give it Mr. Y and state the area, like since it is the case is being the suit is being instituted in Rajahmundry Junior Civil Judge Court. Let us say Rajahmundry. Yes. So always ensure to keep this point. And moving on to the next, let us give like what is the suit first. I mean like a brief fact of the case, like the prior part. This is a suit filed by the plaintiff for recovery of, let us see the amount. It is like I think 50,000. Yes, amount is 50,000. Mention it in words too. I'm not writing it right now. With interest at the rate 20% per annum from the date is 1/12/2023 till the date of realization. What are the benefits of keeping these 2 points is like whenever a plaint is served on the party wide process and all, the party will get to know the advocate of the case and the plaintiff's advocate and what is the suit instituted against the defendants. So always make sure to keep these 2 points in your civil suit, I mean like placed. And next, moving on to the third point, that is like we have a factual scenario like Mr. B borrowed an amount of rupees 50,000 on so and so date from Mr. A at his residence. And let us draft the body of the plaint right now. Let us say like the defendant, we can't use the names Mr. A and Mr. B since in the short course title we have the nomenclature of the Mr. B as defined as Mr. Defendant. So we have to say that defendant borrowed an amount of rupees 50,000 on 1/12/2023 from the plaintiff for the purpose of his for the purpose to repay his loans. So I think that is the reason that is stated. Yes. And mention that here what happened is as a part of the factual scenario has been mentioned like the defendant borrowed a so and so amount and so and so did from plaintiff. The purpose is to repay his loan. And next mention that after receipt of the entire consideration, the defendant executed a pro note in favor of the plaintiff at his residence, agreeing to repay the same with interest. Since he already mentioned with interest at 24% per annum. Let us say like P, comma A on demand either to the plaintiff. He also mentioned that he will pay the amount either to the plaintiff or to his order and deliver the same to the plaintiff on the even date. Yes. So it is mentioned that after receipt of entire consideration, it is the importance of this point is like the defendant executed a pro note only after receiving the certain amount, that is 50,000. That means after receiving the amount only, he has executed a pro note in favor of the plaintiff at at plaintiff's residence. And in the pro note, it is said that he agreed to repay the entire amount with certain interest, like 24% per annum, either to the plaintiff or to any such person as the plaintiff may suggest. And yes, next, moving on to the next, since the entire factual scenario has been uh, contracted and mentioned in the single point, next is like the legal dispute arose because the Mr. B, that is the defendant, is not paying the amount. So we have to mention like in spite of several demands and requests made by the plaintiff, the defendant has not been paid any amount either towards principal or interest to the plaintiff so far. It is mentioned that after taking the amount, the defendant is like is not responding to the plaintiff and all, so that the plaintiff asked the several times demanded like, bro, hey Mr. B, you have taken some the amount from me on so and so date, so at least pay an amount to me. But the defendant has not paid any amount either towards principal or interest. So the point has been clearly specified here. And next we have to mention like the then the plaintiff got issued a legal notice to the defendant on, let us say, give a date like 15th of February, but we should have to mention whether the defendant received the notice or he refused the notice. Let us say like he refused the notice, but the defendant refused the legal notice issued by the plaintiff. So that is the point. See, the entire suit, the factual scenario has been completely covered in 2 points. The fourth point is not mentioned anywhere in the factual scenario, but it is clearly specified and all. Next, we have to mention the cause of action. Since the body of the suit is completed right now, cause of action. See, up to now, 6 points have been completed. There are another 6 points. And you can write the cause of action like this, or you can continue it in the next point, like the cause of action for this suit arose on. So I'm including everything right here. So the cause of action for this suit arose on. Always remember that the cause of action requires certain date, because there will be a prima facie for every legal dispute. For this dispute, it is like the time when the plain defendant, that is Mr. B, borrowed 50,000 rupees from Mr. A. So the cause of action would be like the time when the amount has been borrowed. It is 1/12/2023, and mention that after mentioning the date when the defendant borrowed an amount of rupees 50,000, and mention in words. Always remember when you're drafting any kind when in drafting when you come across any amount like this, make sure you mention it in words too for clarity and all. And it is completed to the point now. And when the defendant executed a pro note in favor of the plaintiff at his residence, agreeing to repay this same with interest at the rate 24% per annum on demand, either to the plaintiff or to his order, and to deliver the same on the event date. And when, so we should also have to mention that the defendant has uh, refused to pay the amount. So let us copy paste this without any delay. And when, in spite of several demands, the requests made by the plaintiff, the defendant has not paid any amount either towards involved so far. And when the plaintiff got issued a legal notice to the defendant on so and so date, and after mentioning this, see, the 2 points has been contemplated into a single point for the cause of action as the gist of the case. So then make sure that the jurisdiction point, to make sure that to convey the court that the court is having the certain power to entertain the case where the plaintiff and defendant resides, and where the transaction took place are all within the jurisdiction of this honorable court. So this is the cause of action for this case, and let us give it a bold text so that it would be easy. And by now we have completed 7 essential elements. Let us quickly complete the other 5. Yes, next we are having valuation and court fees. So valuation of the suit for the purpose of court fee and jurisdiction is as follows. Yes. And the principal amount borrowed on the date is like 1/12/2023, and the amount we should have to mention in the right side. Always remember that 50,000, and the interest rate 24% per annum on principal amount. Let us give it like 50,000 is the principal amount. Let us assume the interest would be like 10,000 since it is a factual scenario, and mention the timeline from 01/12/2023 to, for example, if we are filing the suit tomorrow, always remember that calculate the interest prior to the date of filing. That is, if we calculate the interest up today, then we have to file the case tomorrow. The court will take, for example, if you calculate the interest for 2 or 3 more days excess, it doesn't matter because it won't affect anything. But if you calculate the interest less, and then the plaint may be returned to for subject to corrections and all. So let us give it like today's date, 18 to 2024. And yes, that would make a sum of rupees 60,000. Yes, this is the amount uh, for which we are filing a suit with the interest. The total is like 60,000. And next valuation is completed. The second part is court fee. The court fee of rupees, check your relevant court fee, state court fees act. For my state, the court fees is governed by Andhra Pradesh Court Fees and Suit Valuation Act and is paid as per section. In my state, it is section 20 and schedule and article. I'm not mentioning it. APCF and SV Act. Go thorough. Make sure you're thorough with the relevant state court fees act, because I am only aware of the Andhra Pradesh Court Fees and Suit Valuation Act. And next, let us see which one. Yes, valuation and court fees completed. Next is the prayer part or the relief part. Yes, the plaintiff therefore prays that the honorable court may be pleased to grant a decree in favor of the plaintiff and as against the defendant. So the first one is like for a sum of rupees 60,000. It is not 50,000. Remember that, because with interest it is 60,000. And next, in this same, mention that with subsequent interest, that is at the rate 24% per annum from the date of the suit till the date of realization. And yes, next is like uh, award, pray for some cost of the suit, award cost of the suit. And the third one is like um, make it up like grant such other leaves as the honorable court deems just and proper in the interest of justice. Yes. And by now, the prayer part and the relief part is also completed. And the remaining like signature and verification. For this, you have to mention it like go to the right side, mention, be pleased to consider. And next, since I have already mentioned, both the advocate and the party has to sign. Advocate for plaintiff on the left side and plaintiff on the right side. That is, the advocate will sign right here on the top, and the plaintiff will sign in here. Both of them will sign here. And next, it is the verification and oath part. For this, you have to write like The facts stated above are all true and correct to the best of my knowledge and belief. So, an oath like this should always be given. And next, right after that, you'd have to mention the station date, and again, you'd have to give a signature of the plaintiff. So, since I have mentioned it is like Rajamandri, I'm giving it like this date, as the interest has been calculated for today, and the suit is filing for tomorrow. I will mention it is like tomorrow's date, 2024, and yes, come to the right side, and again give it like the plaintiff has to sign. And by now, I think 10 or 11 of the essential elements of the plaint are completed. Yes, 10 are completed, and the last two remaining are like list of documents. And yes, again, this sign. Always remember that ensure that you incorporate the list of documents in the new page, but you have a sufficient space in this page. You can continue right here. List of documents filed by the plaintiff. Yes. Make sure they are caps. And the first one, as I have said, we should have to follow a logical order. What comes first in this list of document is like definitely the pronote. The pronote that is executed on 1st December 2023. Mention the date first and then go to the right side and then like pronote executed by the defendant in favor. I'm sorry, there is many mistakes are coming in favor of the plaintiff. Mention the amount if possible for an amount of rupees. How much it is like. Pronote was executed for 50,000 as I recall. Yes. And here first document was completed. And next we have incorporated another document that is like the legal notice which was issued by the plaintiff and the date is 15th February 2024. Incorporate the date right here and then go to the right side again. Since the original copy has been with the issue to it, let us write like office copy of the legal notice issued by the plaintiff to the defendant. And by now, two of these are completed. Make sure that they are two in tally like this. Yes. Third one, this keep date like this. And yes, this postal receipt, and if there is acknowledgement, since the notice has been returned, as I mentioned earlier, then the date will also be 15/12. And next, let us assume like we have the notice has been returned on 17th of December, 17th of February 2024, and then like refused legal notice issued by the plaintiff to the defendant. So up to now, these are the five listed documents that we are having right now to for this suit. And then we have the like signature part, that is the I think the last element, signature of the advocate. For list of document, the plaintiff is not required to be signed. This here you should have to write like be pleased to consider, and next it is advocate for plaintiff. Advocate for plaintiff. So by giving it like this, And let us see. So let us move the list of documents to a new page. And yes, so here it is, guys. Basing on the factual scenario, a live plane has been drafted live. See, all the 12 elements are there. Name of the court and suit number in the first. Small cost title, provision, and the long cost title, that is name, address, description of parties, that is plaintiff and defendant both. The body of the plain, which incorporated two major points as I have discussed earlier up to here, and the cause of action, which is the gist of the case. And next we are having valuation and court fees clause, and then the prayer and relief part, and then we are having like the signature part, verification and signature, and the oath part, and again the signature one, and then the list of documents with the signature part. So this is the live drafting of a plaint. And yes, I hope this session is good. And yes,
So that
I think you have enjoyed this session. Yes,
that was a wonderful session, sir.
thank
Does
you.
anybody, we can give 5 minutes for anybody if you have question and answers. We can have 5 minutes Q&A session. If anybody has doubts, you may please raise your hands in the contributors list, and I'll ask you to unmute yourself. Guys, what sir has taught you in the last one. Okay, we have Rukkala Sandeep. You can please unmute yourself and ask sir your question.
Yeah, good evening,
Yes,
sir.
Mr. Good
Actually,
evening, Mr.
you have
Sandeep.
mentioned, yeah, you have mentioned court fee,
Yes.
but there is no such amount was finally calculated for 60,000 rupees. No, you have mentioned.
No, there is certain court fees for 60,000. Andhra Pradesh court fees and suit valuation amount is like 2626, 2,626 rupees. From right from zero up to 3 lakhs, the amount is mentioned in the Court Fees Act.
Okay, that court fees was not included in that 60,000. That is my question, actually.
Yes, I haven't incorporated the court fees in this live drafting plaint because, as I mentioned earlier, there are students from other states too, so they will be confused if I have mentioned the court fees amount there. That's all.
Oh, yeah. Okay,
Yes,
thank you.
you
Thank
should have to refer the Court Fees Act for clarification. That's all, Mr. Sandeep. There is nothing
you.
much more than that.
Thank you. Thank you.
Yes, yes, my pleasure.
So Sambhav Badkul has a question. You may please unmute yourself and ask the question, Sambhav.
Sir, the line which you have drawn by dot dot dot, that was mandatory or not?
No, Mr. Samba. I mean, it is not mandatory because I have drawn the line just to differentiate the body of the plane from the description of the parties. That is from long course title. That's it. It is not mandatory, but I will use it in my planes. You may use it or you may not use it. It is up to you. That's all. It is not mandatory.
Okay, sir. Thank you.
Yeah, my pleasure.
Um, does anybody else have a question? We can have one last question if somebody else has a question, or we can end the session. Um, yes, sir. I think that is all, sir. I think Rukkala Sandeep is raising your hand. Do you have a question? Okay, okay.
Yeah.
Okay.
Yeah.
So I think that is all the questions for today, sir. Sir, you giving your time is highly appreciated to students today. A small note to everybody. A small note to everybody is that what sir taught in the last 1 hour is something that takes roughly, roughly 3 to 6 months to even understand the structure and all. So I'm. I myself am really grateful for sir to structuring it so well and helping all the students who have appeared today.
Thank you.
Sir,
Thank you so much. For
in,
me to
in
understand it, it is like I took almost 6 years to know about this drafting and all because right from 15 years of age, I am involved in drafting and all. But
yes,
that is very engaged for me to understand what is what because I am very new to it. Right after my 10th, I am doing the drafting. But after joining this law degree, and I am very well versed with the drafting and all. So when I must say that the thanks goes to the legal age team, not to me, because you have approached me and told me to give a class. but I thought like instead of giving a theoretical class, it is better to give a practical class because drafting is something that is not we will be taught or given by anyone in the practical life. Because I don't know why it happens to everybody, but I think that everyone deserves a chance to learn about the drafting. So I thought that it would be best to teach the drafting. So I thought like instead of saying the a plane should contain this and this, if we draft a plain live while in live, basing on a factual scenario, it would help the students. So I thought it helped. It would have helped some of you. If not, then I'm sorry for not meeting your expectations. Yes.
Sir,
I,
the session was really amazing, sir. Like, I mean, I think I speak on behalf of everybody who's attended that it was a very structured and a very informative session.
yes.
And
Yes.
definitely add value to anybody who's attended the session. And for people who are not able to make notes and any of such problems, we will be uploading the session on YouTube. On YouTube on Legal Leech's channel, so you guys can actually revisit the session and make notes and revisit the session, and you can practice as sir said. So that's all for now from Legal Leech. I thank sir for accepting Legal Leech's invitation and giving such a nice session, and I thank
I mean, like,
all the participants who attended the session and made use of the time that sir has given to everyone. Thank you, sir. Thank you.
thank you very much. Thank you.
I'll be ending the session. Thank you.
Yes. Thank you for having me today.